Welcome to Legally Speaking with me, Tarun Nangia. In a significant constitutional moment yesterday, Justice K.V. Vishwanathan and Justice B.V. Nagaratna, who incidentally both are going to become the incoming Chief Justice of India, have delivered a powerful dissent on the interpretation of the Section 17 of the Prevention of Corruption Act. Now, what that dissent is, what are the implications? Simply to analyze this judgment, I have an eminent panel who have joining us after perusing the judgment briefly. I know it was very little time. It's just been a little over 24 hours, and they've been able to make time to give their initial comments. I want to welcome Justice Talwan Singh, who's now a senior advocate at the Supreme Court of India. Good to see you, sir. Thank you for your time. I have with me senior advocate Vikas Pava, who's an arguing counsel at the Supreme Court of India. Good to see you. Thank you for your time. I have with me advocate Sri Venkatesh, who argues at the Supreme Court. Good to see you, Sri Venkatesh, and looking forward to your insights. So, at the outset, let me request Senior Advocate Vikas Pava to deliver his initial comments on this judgment. Over to you.
Yeah, thank you, Tarun, for inviting us. Although you have given us very little time to read this very, very thick judgment, and I think one of its kind, where two dissenting judgment, both are more than 100 pages. So to tell you, tell your viewers about the brief history about 17A, it's very important that we analyze what exactly happened in the beginning. This all started in 1997. Before 1997, there was a single directive which was issued by the government to the CBI that whenever you have any complaint against a public servant who is above the joint secretary level, then kindly take approval from the senior authorities. That was an executive direction issued at that particular point of time, which was challenged in the Honorable Supreme Court, and our extensive argument that single directive was declared unconstitutional. So it was struck off. But however, that was the only provision which was, seeking some kind of protection for the public servants. Once it was struck down, then the government came up with a new provision in the Delhi Special Police Establishment Act. And Delhi Special Police Establishment Act is an act which governs the operation of CBI. CBI is a statutory authority. It came under this act. So that was called Section 6A. 6A was introduced on 11th of September 2003, after the judgment declaring single directive as unconstitutional. Now 6A was also challenged in the Honorable Supreme Court by Mr. Subramaniam Swamy. That also carried on for many, many years. Ultimately in 2014, after about 11 years of its operation, it was also declared unconstitutional. The primary reason was that 6A only protects officers who are joint secretary and above. It doesn't protect every public servant. It only protects a section of public servant. Therefore, it is discriminatory under Article 14, and therefore it was struck off again. That happened in 2014. After 2014, 17A was introduced in 2018. Now 17A, of course, was the intent and purpose of 17A is the same, to protect the honest public servants, the public servants who are, recommending something to the government, taking a call, taking a decision, which is very important. So to protect those honest officers, to be fearless, to be fair while taking a call in the government and working, 17A was introduced. This time 17A was again an old wine in new bottle. Instead of joint secretary and above, the statute says all public servants are covered under 17A, whether joint secretary, below joint secretary, above. So that discrimination which was mentioned in Subramaniam Swamy's case was removed, and 17A has been brought in. 17A, however, limits, this is very, very important. 17A again limits only to those public servants who are committing an offense in relation to any recommendation or decision being taken by them in discharge of their official duty. Now, these two lines again become very contentious. 17A is challenged before the Honorable Supreme Court, and now we have a verdict in 2026, 13th of January 26, where there are two different. There is a split verdict by two different judges on various grounds. Justice Vishwanathan says that it is constitutionally valid. He, however, says that the approval should be outsourced to an authority rather than the same public servants who are seniors to a probable accused. When he examines, let it be examined by an independent authority. And Justice Vishwanathan says, let it go to Lokpal as far as union is concerned, and Lokayukt as far as the state is concerned. But he says that the provision is valid, it's constitutional. We certainly require it for the honest officers, and the entire exercise should be done within the same time frame, which is 3 months, which is given in 17A. However, Justice Nagaratna now says that it is completely unconstitutional because you are trying to reintroduce Section 6A, which was declared as unconstitutional. So it's the same provision with some modification and changes. You are bringing it now in the form of 17A, which is not permissible. So therefore, it is unconstitutional. One additional ground which the Honorable Judge says is that, again, it is discriminatory. I read those 2 lines to you, that it is discriminatory because it restricts only those public servants, those who have either given any recommendation or they are taking a decision while discharging their official duty. What about the officers who are not giving any recommendation, but they are part of the entire process? They are not covered in 17A. Again, it is discriminatory under Article 14. So this is one reason. And second, the Honorable Judge also says that 17A is arbitrary because it prohibits any kind of inquiry. So the 3 words which are used in 17A is inquiry with I, inquiry with E, and investigation. So the Honorable Judge says that how can you have a provision of law which does not require or does not permit even an inquiry against an officer? If he has not done anything wrong, why not there be an inquiry? So the Honorable Judge says it is completely arbitrary because it prohibits any kind of investigation or inquiry against that person, who may be an accused, who may not be an accused. And then the Honorable Judge says, how can I say that a particular provision of law is valid and constitutional just because we are trying to protect certain honest officers? That can't be the ground on the basis of which you are saying that let us declare one provision of law as completely constitutional. And third and the last, the Honorable Judge says that how can you, while dealing with the interpretation of 17A, comes up and substitute an authority, because the word used in 17A is government and an authority. How can you substitute Lokpal or Lokayukt instead of central government, state government, or authority? We don't have the power. The Honorable Judge says we don't have the power in Supreme Court. We are interpreting. We can't substitute words. We can't introduce an authority that you are declaring 17A as constitutional, but outsourcing it to an authority like Lokpal. That is not permissible in law. So these are 4 or 5 grounds on the basis of which Honorable Justice Nagaratna says that it is completely unconstitutional. It should be struck down. Now there is a verdict. Now there is a split, and matter has been referred to the Honorable Chief Justice of India, where of course now we'll be having a new bench and the entire argument will take place again, I think. So this is the history. So in nutshell, I have tried to present what.
Thank you for giving all about. Thank you for giving these detailed introductory comment, Senior Advocate Vikas Pava. I'll go to Advocate Sri Venkatesh for his opening comment.
Thank you, Tarun. Of course, the expert has already spoken, so there's not much for me to add. But it's a very voluminous judgment, but I think it also deals with a very interesting jurisprudential issue, which I think is also at the heart of this matter. See, Justice Vishwanathan's judgment has taken the presumption of constitutionality in favor of the provision, which is actually an accepted practice, that when there is an enactment by the parliament, there is an inherent presumption of that the provision has been made validly and it is constitutional. And therefore, the judgment that he has rendered goes on the broader principle that once you find a provision of law which is constitutionally made in terms of process, then you cannot strike it down merely on the apprehension of abuse. He does, of course, in his own judgment, deals with the 2 previous judgment of the single instruction as well as Subramanian Swamy. And of course, he says that the Subramanian Swamy judgment, which dealt with Section 6A of the Delhi Special Police Establishment Act, was dealing on classification, more so on the issue of a person being in judge of his own cause. But his approach to dealing with the judgment seems to be in favor of leading towards constitutionality and holding and saying that you can't throw the baby out of the bathwater today merely because you apprehend this judgment is going to create problems in times to come. That seems to be his theme, at least his judgment that has been delivered. Justice Nagaratna, however, looks at the effect of the provision. She looks at what was the issue at hand in the first round, as Mr. Power rightly pointed out, when the single instruction was issued. What was the core controversy when Section 6A of the Delhi Special Police Establishment Act was being debated about? And in all these cases, the argument was indeed that you are creating a specialized body to investigate into offences, and there is obviously police which does so in addition to CBI, but you're giving the reins of that body to the person who they're going to investigate into. That argument was actually made, and therefore she says that, like as Mr. Pava very eloquently said, her judgment goes on to show this is nothing but wine in a new bottle. Because what you've done is you have overcome the hurdle of Section 6A by now adding this provision under the Prevention of Corruption Act. And therefore, in her judgment, she holds that this is, of course, not something which is constitutionally sustainable, because there has been two judgments in the past on a similar issue, if not the same. So that is the overall theme. One more thing which sort of jumped out to me when I was going through the judgment is the fact that here both kinds of inquiry and inquiry are both prohibited under the new provision, which Mr. Pava also alluded to in his opening remark, that this is something which is, of course, a very, very vast safeguard in favor of bona fide government employees, that even an inquiry into their actions can't be done unless you have an approval from that government. So that is something which even Section 6A of the Delhi Special Police Establishment Act did not comprehend, and when it was applicable between 2000 till about 2014. So even in that period, this kind of a embargo did not exist. So she, of course, ruled that this also makes it wholly unconstitutional, because you're effectively saying that this none of this can commence. No investigation, no inquiry can begin against a public officer merely because there is a protection under Section 17A of the Prevention of Corruption Act. So this is broadly the two judgments are, of course, they have dealt with effectively the history of this provision as well as the previous two Supreme Court judgments very elaborately. But this is broadly the theme of their two judgments.
Thank you, Advocate Sri Venkatesh. In a lighter vein, I would like to say, now that the arguing counsels have spoken, we'll go to Justice Talwant Singh, who can comment.
What is verdict?
Basically, I think both the learned counsel, they have presented both the views, Justice Nagaratna and Justice Vishwanathan's. I've been a CBI judge, and Vikas Pava used to appear before me, so I know how difficult it is to proceed with the corruption cases in court. I think 3 days ago or 4 days ago, I read a newspaper, there is a news in the newspaper saying in respect of one police official in Haryana, the sanction was denied in Section 19 also. If we talk about the safeguard, 197 in CRPC and Section 19 in Prevention of Corruption Act, they duly safeguard the government servants and especially the honest government servants. So now this definition of honest is, of course, in the, you have to be very careful about who is honest in whose life. So, and I think Mr. Pava is also aware, and I was really aware of that. Many charge sheets were filed, and even today they are filed without this section. We used to wait for years together only for that sanction to come in. And when the sanction will come in, of course, it can be a sanction, it cannot be a sanction. So if the purpose of Section 17A is to protect the honest public servants, that protection is already there in the Act itself. Number one. Number two, comparing in Justice Vishwanathan's judgment, I think at one point of time he said that these provisions are already existing, so this is an addition to that. No, that is not there. 197 and Section 19 of Prevention of Corruption Act, they don't interfere at the investigation stage. Because there you need a total independence. The judiciary cannot interfere, then why should the executive interfere? This is what my own take is. And CBI go in a very systematic way. They have a SOP in place. They will first register a preliminary inquiry. So that will take and it will pass through many stages. After that stage is over, and these are basically inquiries which are made in a discrete manner. And after they are sure that there is something fishy there, only then they register a regular RC, regular case. So if we talk about the precautions are there. Then again, you are creating, basically, you are putting CBI under Lokayukt or Lokpal. These are independent agencies. CBI, CVC, Lokayukt or Lokpal, they are independent agencies. One cannot be put under the other. Next thing, how can you read in a statute government as Lokayukt or Lokpal? I think Justice Nagaratna has rightly observed that it is not our duty. If the government tomorrow wants to amend the act and use the word Lokayukt or Lokpal there, of course, they have a right to do so. But how can the court read it down in that direction? That can't be done. There can be, there may be a time when the government takes the call and make Lokpal and Lokayukt more powerful and, of course, dealing with these 7 inquiries. And again, there is another discrimination. A Lokpal or Lokayukt can investigate into all the complaints without there being any sanction. Why should CBI take this sanction? So this is my initial take on this.
Thank you for sharing these comments. I'll go to Senior Advocate Vikas Pava. So many times the issue of fishing and roving inquiries is sort of said in the context of government servants that this is done to prevent a fishing and roving inquiry. Could you reflect on that issue? I mean, because a fishing and roving inquiry could also be against a private businessman. It's not only the preserve that a government officer would be sort of victim to that. So could you inspect and examine it from that angle?
Well, there's when we look at the life of a public servant, particularly when he's representing central or state government, these public servants take some very, very serious decisions. Decisions which may be economically very, very important for the government. The amount involved, the contracts involved are in crores and crores of rupees. There are a lot of private parties which are involved. There is a competition in the market. So if contract is given to A, B will be aggrieved. So just like any other society, in our society also, there are instances where false complaints are filed by disgruntled people, by the parties who are not getting the contract. And it's an accepted fact in our society. So objective of 17A is to protect those officers who are taking an honest call, who have applied their mind, taken a decision in favor of the government, right or wrong, according to them, according to their wisdom, they have taken a decision. And when there are complaints which are filed by disgruntled people or aggrieved parties, they have to be taken very seriously. Now, those complaints, suppose they are found to be false, then action should be taken against the people who are filing the complaint. I'm talking about the complaints which are filed with a name. These are not, anonymous complaints. Very often we file anonymous complaints also filed. So 17A, if you see, is like an embargo or a protection for an officer who is protected for any kind of roving inquiry, frivolous inquiry, anonymous complaints which are filed. That's a protection. But what the Honorable Supreme Court has seen, and I think Justice Vishwanathan has noted down in his judgment, that the government has refused approvals in 41.3% of cases. Out of 2,395 cases, in 989 cases, the prior approval was refused. What the Honorable Judge was trying to say is that there are instances where the government would certainly like to protect its own officers and may not protect the other officers, because it's all subjective satisfaction of the authority which is taking the decision. Therefore, Justice Vishwanathan was of the view, let's outsource it. Let us give it to an authority like Lokpal. Lokpal is not connected with the decision making. Lokpal doesn't know what is happening in the ministry. Lokpal is not aware of the seniority and junior, relationship between the public servants. So they will be independently able to take a decision. Lokpal Act also says if Lokpal is initiating an action against a public servant, then 17A is not required. That is why Justice Vishwanathan was of the view that let's give it to Lokpal. Lokpal already has that power. And if Lokpal is initiating, then 17A has to be overlooked. So why not involve Lokpal as an independent authority who will apply their mind, and they have the wherewithal. They have their strong officers to conduct inquiries on their own. So therefore, we have to protect officers from the fishing and roving inquiry, also against the frivolous complaints which are filed. So therefore, I personally feel as a criminal lawyer that we need to have a mechanism to protect these officers. Right or wrong, there is a 17A. 17A can be, properly appreciated. And even if it is a misuse, even if there are some instances where it has been misused, that is not the ground for declaring it as unconstitutional. So I would bend a little bit towards what Justice Vishwanathan has said, because if there is no protection at all, then we are giving the entire power in the hands of the investigating agency, like CBI, or for that matter, or ED, or any other agency, where there is no checks and balances, where the government is unable to protect their own officers. So we need some mechanism. In case the mechanism is being misused, then we have to curb that misuse. And we should encourage these, honest officers to be independent and fearless while taking decisions in favor of the government.
Thank you for explaining this in perspective. I'll go to Advocate Sri Venkatesh. Venkatesh, you deal with a lot of corporates at the commercial level, a lot of commercial cases you do. You understand the complexity involved in looking at a case in hindsight. In hindsight, everything looks long many times. And at that moment, nobody wants to decide. So the bureaucrat who decides is then questions, and then he many times says that nobody was willing to take a decision I took, and now I'm being fixed. We see this in many cases. We have spoken on this before, so I want you to reflect on this issue.
So, Tarun, if you remember, we had done one show on ONGC chairman discussing how matters could be settled in commercial disputes, where one of the suggestions he made was that why can't, before getting into a protracted litigation, why can't, as an employer, you decide what is due and payable to a contractor and make that payment? So this is that catch-22 situation. If you do it, you are damned. If you don't do it, you are damned. That's the problem with while working as a public sector undertaking, or as a government or a civil servant, because the issue there is that if I were to take a pragmatic view as a public servant and see that what is in the betterment, that I finish the project in time, I pay what the contractor is due, then later on, if the rival party can start some proceeding against me, or can at least make an FIR or make a complaint, as Mr. Powers was referring to. And if I don't do it, then the project suffers, then the economy suffers. So undoubtedly, I think we are all ad idem that there is a requirement of having some protection and safeguard for bona fide public servants in discharge of their official duties. There is no doubt about this. But the real question in this matter is, in my understanding, and which will be debated before the Honorable Supreme Court, maybe and perhaps in a larger configuration, is that the judgment rendered by this very Honorable Supreme Court in 2014, the Subramanian Swamy case, was it only on the basis of classification, or was it really on the basis of a person being judged in his own cause? If the answer to the question is the latter, that in addition to classification, this issue was also inherent to the very provision of Section 6A, and therefore, that by that logic, even this section goes, then even according to me, even this section will not see too much progress, because ultimately the court has taken a view that these kind of protections are unconstitutional in different facts and circumstances. So that's really the debate. But I do feel that before an investigation is ordered by one of these agencies, the fact that a function has been discharged by a person in discharge, any decision has been taken by a person in discharge of his duties, that ipso facto does not lead to criminality, and therefore a pragmatic view is required to be taken. Now, what is that safeguard? I would not be in a position to hazard a guess today that what would be a perfect situation. Would it be Lok Ayuk, Lokpal, or the government itself? or perhaps a different mechanism, perhaps a mechanism where the investigating agency can proceed with investigation, and the government has a right to step in at a relevant point in time and stop that investigation or stop that inquiry and say that, look, this is in discharge of this bona fide purpose, we don't want to look into it. So which way the ultimate law will evolve, we don't know. But yes, this is a problem. It affects us, and we as lawyers who do these matters, who are facing these disputes where decisions are not being taken in time or are being delayed, we see the ramification of that in years to come, not just in the particular dispute in question, but at public at large. Therefore, I think the right balance is required to be struck, and this is what I think one is looking at in terms of such protection safeguard. But yes, the safeguard is required. I don't think anybody can dispute that. Tarun, you're on mute.
Thank you, Advocate Sri Venkatesh. As I say, judge is always the last word. So I'll go to Justice Talwan Singh for the last word, and any dilemma that he has that, if how do you sort of judge whether a decision was bona fide or a decision was sort of, done with a malafide intent? And because in the end, sitting in judgment, I think that's one of the toughest calls one has to take, which a judge does day in and day out.
Tarun, we always wait for your call because it gives us a cause to do some research. And I was astonished to see the definition of public servant today, Section 2 of the Prevention of Corruption Act. One of the clauses is 2(6), Roman 6 is any arbitrator or other person to whom any cause or matter has been referred for decision or report by a court of justice or by a competent public authority. So even as an arbitrator, I am also covered.
That's right.
In the definition because I was not knowing this. I was just looking at whether only public servant, what kind of public servants are there. So even retired judges are covered by that Protection Act. We have a special act when we are in service. But when we are not in service and performing the duty of an arbitrator, we are not covered. We are covered in the definition of public servants. Yeah. So if you have to take a call, final call on all this, I think basically a balance has to be maintained. I think there is no doubt the honest officers have to be protected, but protected at which stage? This is a big question. In my view, the existing provisions, sans Section 17A, they are quite powerful. They are being used by government every now and then, and there are many instances where the sanction has been declined by the government, or earlier it used to be endless delays also, and that delay itself sometimes results in whether the sanction is of any use or not when it is granted. 197 in CRPC and Section 19 they cover this aspect already. 17A is basically a reaction to Section 6A being struck down and earlier those executive directions. And as Justice Nakarshna has rightly said, that it is an old wine in a new bottle. So you just play with the jargon of the words and make sentences a bit more flowery. It doesn't take away the intent of Section 17A, which is in fact Section 6A itself. And why you want to protect only people who are taking decisions or who are making recommendations? If you want to, they said it is not discriminatory. It is not creating a class. It is creating a class. If you want to protect, you protect every public servant. Let there be a say approval before sanction. Of course, they have taken out those trap cases out of that or the arrest cases. Fine. But what's about other public servants? Who are performing their duties? You have taken them out. So of course, this is discriminatory, and I don't know what will be the final view of the Honorable Supreme Court, but I tilt in favor of the judgment of Justice Nagarathan.
Tarun, you're mute. You're on mute.
Thank you, Justice Talwan Singh, for your view and sharing it with us. I would like to thank Senior Advocate Vikas Pava, Justice Talwan Singh.
Can I say only one thing, Tarun? Why we need 17A is, if we see the old Act, in the old Act, Section 13, 1D, Roman 3, is an offense when a public servant, although had no dishonest intention, takes a decision which is contrary to public interest. I hope I'm making myself clear. There is no dishonest intention, there is no corruption involved, there is no quid pro
Yes.
quo, but he takes a call which is contrary to public interest. According to
Okay.
that Act, 1998 Act, before amendment, it was a criminal misconduct punishable for 7 years. So the
Okay.
public servant says, I am taking a call according to my wisdom, according to my understanding. You are saying it is in public interest, it is not in public interest. I am not concerned with that. I have a file in front of me, I have taken a call. But you want to prosecute me. So whether these category of people, whether this class deserves to be tried and convicted is something which is very, very important. He is not taking any bribe. You have selected him. He's now a minister, or he is a joint secretary or a secretary of the government of India. He has his qualification. He's taking a call. But somebody sitting high up says it is against the public interest, and he's facing prosecution under Prevention of Corruption Act. So all these cases should be scrutinized. There should be a filtration process. That's why we require 17A for the protection of those kind of people who are honest, who are taking a call according to their own wisdom, and they're independent.
It's a very, very valid point that you shared, and I think this should be reflected upon, because in hindsight, a lot of things may look wrong, but at that time, that man has to decide. The wisdom of hindsight is everyone has it. Thank you for sharing this nugget of wisdom with us. I would like to thank each one of you coming on today's show on very important subject. Of course, this will be reflected and debated upon in the months to come, and we shall be part of that conversation. Appreciate you joining us. Thank you so much.
Thank you.
Thank you. Thank you.